From the college by the lake, meeting the personalities and discussing the issues that affect all of Coeur d'Alene and the inland Northwest. We are the North Idaho College Public Forum. And now here's your moderator, political scientist Tony Stewart.
During the 19 years of the broadcast of the North Idaho College Public Forum, we've had the opportunity to have a number of very special programs, but I think today would certainly top the list. We're so pleased today to welcome to our program the entire Idaho State Supreme Court, and we've invited them because this is the Centennial year, and it is called the Centennial Court. All 5 members of our state court are with us, and I would first of all introduce to you the Chief Justice of our court, Robert Bakes. Our Chief Justice is the only member of the current court who has served as Chief Justice of our High Court. He was born in Boise on January 11th, 1932. He attended Boise schools and Boise Junior College and took his law degree at the University of Idaho Law School in 1956. Chief Justice Bakes has been on the court since December the 30th, 1971. Mr. Chief Justice, it's a pleasure to have you here.
Thank you.
The second member of our court is Justice Stephen Beislein, who came to the court on May the 20th, 1976. Justice Beislein grew up in southeastern Idaho and spent half of his professional career in northern Idaho, and we feel that he is one of us in North Idaho, and it's been on the court, as I said, since 1976. He was born in Pocatello. He spent 5 years with the U.S. Navy, and he received his law degree at the University of Idaho in 1949. Justice Beislein, welcome to our program.
Thank you.
Our third member of the court is Justice Byron J. Johnson, who came to the court on February the 1st, 1988. He was born in Boise on August the 2nd, 1937. He attended public schools in Eagle and Boise. Justice Johnson took advantage of an academic scholarship, and he attended Harvard College, graduating with honors in 1959. He was graduated from Harvard Law School in 1962. Justice Johnson, welcome to the program.
Nice to be here, Tony.
It's also a pleasure to welcome Justice Larry M. Boyle, who came to the court on August the 22nd, 1989. He is the only member of the current court who previously had served as a district court judge. Justice Boyle was born in Seattle, Washington. He attended public schools in Pocatello, Idaho. Justice Boyle received a degree in economics from Brigham Young University in 1968, then his law degree from the University of Idaho in 1972. Justice Boyle, welcome to our program.
Thank you very much.
And I'm also very pleased to welcome to the program the fifth member of the court, Justice Charles F. McDevitt, who came to the court on August the 31st, 1989. He was born in Pocatello, Idaho on January the 5th, 1932. He attended public schools in that city and graduated from Idaho State College, which became Idaho State University, before receiving his law degree from the University of Idaho in 1956. Welcome to the program, Justice McDevitt.
My pleasure.
In helping or assisting in questioning our distinguished guest today, I welcome 2 members to the panel. First of all, Janelle Burke, who is an attorney in Idaho, and she is law clerk for the administrative district judge of the 1st Judicial District. And next to her is Scott Reed, who is also an attorney in Idaho and was one of the authors of a book that I want to show you, which is a very special book for the Centennial Court entitled Justice for the Times. And this particular book is published by the Idaho Law Foundation and is available in either hardback or in paperback. At this time, I would invite Janelle Burke to commence our questioning.
The Idaho Supreme Court is celebrating its centennial anniversary. However, there was a judicial system during the territorial days that preceded statehood. Chief Justice Bakes, can you describe for us, please, what kind of atmosphere existed in the court system in the Idaho Territory?
Well, you need to first understand the kind of people that were in the state of Idaho in 1863 when Idaho became a state. They were primarily miners. They'd come from, most of them, or many of them, from the western Washington area when gold was discovered in northern Idaho. And there are also some those who had left the South to get away from the Civil War, and the result, it was a hardy bunch. There was little law. There were few, if any, judges. They were a widespread population, and it was a rough and tumble sort of a society we had. And so the first judges that were appointed to come here really had a difficult task on their hands to try and bring law and order to a group that was essentially individualists who The only law was the law that they established in their own mining camps, and it was an interesting situation, difficult situation.
Then what happened, Justice Johnson, when the Idaho Territory became a state?
Probably the most important development was that judges became elected. They had been appointed by the president before that time, and usually, as the Chief Justice has intimated, from people outside of the territory. Those initial 3 elected in the fall of 1890 began to operate a state court system composed of Idahoans, elected by Idahoans, administering justice for Idahoans. And they were very energetic. They launched into immediate sessions of 6 days a week in February of 1891, and they did fulfill their responsibility to come to northern Idaho, sitting in Lewiston in April of 1891. They began to deal with tough issues, and having read many of the early opinions, I have found that they were well educated, they were articulate, they understood legal principles, and they formed a foundation that had not existed in the territorial courts. They began to establish precedents, some of which we follow even today.
Scott Reed.
If I can ask a question perhaps of 2 members of the court, Justice Weisland and Boylan, I would like to jump way ahead to current times. It appears to me, though this may be all first experience, that you're rather enjoying being on television, and I know that I was a witness to the television program that was the 21-21 debate over whether the Lieutenant Governor could cast the deciding vote or not, and I thought it was thoroughly enlightening and enjoyable. I have to tell you, my wife thought the decision was wrong. But aside from that, you allow television in your court, and yet, as I understand it, the rules prohibit the use of television at the district court level. I just wondered on what basis this discrimination exists. Is it that only the people with black robes sitting on the high bench are telegenic, or why is it that you do not allow the televising of proceedings at the trial court level, where a number of other states allow that? My question is to both of you.
To me?
To both.
Yeah, you shouldn't drop that on Justice Boyle, because he wasn't here when that terrible decision was made.
I'd like to hear from either.
That's all I have.
Scott, obviously the 5 of us are not terribly photogenic, as you can tell. So it's not because those who wear the black robe are more photogenic or easier to photograph. The reason, from my perspective as a former district court judge, the presence of cameras can be awfully intimidating. And they can also send a message that what is being photographed is terribly important, perhaps controversial, perhaps newsworthy. Having presided over several high-profile cases, jurors may feel intimidated by the cameras. They may feel that more significance should be given to a given case because of the presence of cameras. And it can also cause these people to lose perhaps some of their sense of security of being jurors. For that reason, I was quite insistent that the news media not be allowed inside of the courtroom. I had, in several cases, requests by the news media when I was a trial court judge to let them photograph the ceremonies. I felt that it would be inappropriate and place some significant pressure on the jurors. For that reason, I think that it's appropriate that the position that this court has taken long before I came to this court, that cameras not be allowed in the courtroom, I think it's appropriate. And I followed that rule. Obviously, once the trial is over, jurors are free to talk with the news media, which I always told them they were free to do. But I felt it was appropriate to not have cameras in the courtroom for the atmosphere it might create.
My question is directed to Justice McDevitt, and I know from some reports I've read that nationally the court system of Idaho is looked upon as a very much a model in its structure today, and certainly the state Supreme Court has been recognized as one of the most effective in the country. And I know, Justice McDevitt, when you were a member of the state legislature, you were very involved with the legislation for court reform, and this court, the state Supreme Court, at that time was also very supportive. Would you discuss with our viewers that whole issue of court reform and what it did for the courts of this state?
Well, in the legislative session of 1968, I headed up a statewide committee that proposed court reform. And it was for the first time to do away with the probate judges and the justices of the peace that had been here since constitutional days that Justices Johnson and Bakes talk about. And there were at least 2 of those in every county. The larger counties, Coeur d'Alene, had 3 or 4. And so we were affecting people at the local level, but the time had come to make this system more manageable, to make it modern, to make it integrated as it now is. The legislature heard our argument, adopted court reform. There was a new governor, Governor Samuelson, from just up the road, who didn't fully understand what we were doing. He had just come to office that year. He got significant pressure from his county and other counties. Don't do away with our jobs. Don't eliminate our probate judge. And these were popular people. They were good people. So Governor Samuelson vetoed the legislation. We overrode the veto in the Senate, and the book you have will quote me from that time saying I thought I had the votes to override it in the House, but as Scott Reed and his wife will tell you, those things change from minute to minute. I think we lost by 3 votes. But the committee stayed intact. I left Idaho in June of that year, 68. Tom Miller and Jim Lynch, who were part of that committee and who really spearheaded that reform movement for another 10 years, succeeded. Where I had failed the second year, Governor Samuelson supported it once he understood it, was an advocate of it, and court reform came to Idaho. And I think history's proven it was a good move, that the legislature did well, and the governor acquitted himself in the end quite well.
And for our viewers, particularly who are out of the state but admiring what we're doing here with our centennial year last year and now the court centennial, could you just briefly run us through the basic structure of the levels of the court that came through that reform?
Well, under our Constitution now, and it wasn't immediately in that reform, but subsequently, the Supreme Court of the state of Idaho administers an integrated court system. The real bulwark of the court system, however, are the district court judges, and with them the magistrate judges, who try the actions. The magistrate judges try actions up to $10,000 in most cases, with the exception of divorce actions, and they might handle a divorce estate with $100 million in it. The district judge then is the trial level, and in the last 10 years we have adopted a court of appeals, which assists the Supreme Court in hearing appellate matters. All appeals are taken to the Supreme Court. They are then, some of them, assigned by the Supreme Court to the Court of Appeals. We think it's a good system. There are meetings on a regular basis between the district judges, the magistrate judges, the Supreme Court, and the Court of Appeals. And each of the districts of our state, there are 7, have an administrative district judge who is really responsible, together with the county commissioners in the various counties, in administering the judicial system in each district. That's basically how it works.
Thank you. Janelle Bird.
I want to continue on with some of the history of the Idaho Supreme Court. And Justice Beislein, can you tell us about some of the North Idaho justices that have served on the Idaho Supreme Court throughout our history?
Would you repeat that a little bit louder?
Can you tell us about some of the Supreme Court justices who have come from the northern part of our state? Some of the people who have served.
Do that.
Okay.
Be happy to do it. 2 of my heroes. And one, of course, is Emery Knudsen from Coeur d'Alene. If I've tried to emulate anybody in my activity on the court, has been Emery Knudsen. He was a perfect gentleman, a scholar, and a great jurist. And before that, it was Herman Taylor from Sandpoint, Idaho. He wrote probably the most outstanding opinion on search and seizure that's been written in the United States.
And the name of that case is?
State versus, now I'm not very good on my Basque, but State versus Eureki. About 43, Idaho, I think.
Scott Reed.
Let me follow up. Justice Boyle, you mentioned that you had your experience as a trial court. And we live in a time when many more people watch television, participate in television, are aware of television than, unfortunately, in my viewpoint, read the newspapers, read the rest of it. And part of the whole judicial system is an education system. Are you not, by limiting the exposure of the public to what actually happens in the courtroom instead of the defendant coming out or the lawyer coming out talking about it, the exposure of the people to it. And the second part of the question is, that was your decision as a trial court judge. Why is there a rule from the Supreme Court that says all the judges at the district level have to follow what you have explained as being your reasons?
It's interesting to note, Scott, that in those trials, it was primarily the defendant who would request that there be no media present. The defendants were concerned that if the news media were in the courtroom taking pictures, it would be, first of all, distracting. Second of all, it could be prejudicial to the defendant in a given case. I was very sensitive to that. I wanted to make sure that these men or women who were being tried with who were being charged with significant crimes, being tried before a jury, had a fair trial. And it was basically that reason that I followed that rule. With regard to the 21-21 split involving the Sweeney versus Otter case, I did not participate in that case. I watched it on television like you did. I brought a small television into my chambers and I watched that proceeding. The reason I did not participate, and it was with great disappointment because I was thoroughly fascinated by the issues presented, is that one of the party's defendant, a state senator, is a former law partner of mine, and he and I still own to this day some real property together. We own an office building in Idaho Falls. And it would not be appropriate for me to sit on a case where there was that type of a conflict. I was fascinated by the television coverage of that proceeding. I watched it with great interest, with envy and with a desire to be present, but I knew I could not. The proceedings were a remarkable education facility for our people. The only explanation that I can give as to the difference is that at the trial court level there are defendants' rights that may be adversely affected, or people's rights that may be adversely affected by the presence and the clicking and so forth of television cameras. Whereas at the Supreme Court level, we're talking about questions of law rather than questions of fact. And with that distinction, I feel it's a good distinction to make.
You made the distinction in a criminal case of the defendant having a right, and I think that is always a weighty matter. What about the civil case? Once in a great while, there's a civil case of interest at the local level. I've never participated in one, but I mean, there have been ones where people have been
Sure.
interested in the results. What would be the barrier in having a...
Oh, the same reason, perhaps. If a jury were to have great press coverage, they might give some portion of the case greater emphasis or weight than other portions. For example, if the news media who come at unusual times because of deadlines and press times they have to meet. And if they were to come and take a photograph or to be present during a part of the trial, the jurors might think that was more significant when in fact their presence was really just coincidental. The jury, the courtrooms are always open. The public can always come to jury trials, they can always come to our proceedings. And so I think that access is there if the public is aware. Wherever we go in the state, we have courtrooms full of high school students. We encourage that. I used to have, as a district court judge, classes come and watch parts of trials. And so the courts are available and open, and access is readily available if people want to watch it.
Chief Justice Bakes, I would like to get into another area that's really a great pride of the court, and it's very helpful to attorneys and clients and people around the state, because we are such a big state geographically. You've had some real change in technology as it's come along, and as you hand down decisions, how those can be accessed almost immediately. Would you share with us the new technology you're using as a court?
Well, you mentioned the availability of our opinions immediately to the public through our bulletin board and our clerk's office, but I think that is an important advancement. They're available to anyone, anywhere in the world who has a computer and a modem and can ring up our bulletin board number and get them. But I think the more significant thing is the fact that we are in the process of installing in each of our counties, in our clerk's offices, a computerized system in which all of the record keeping of our courts will be done on a computer, so that when that is completed, and it will be a while before we do it, that the entire system will be accessible from remote areas, so that if the media, for example, or any citizen wants to go to a public terminal, they eventually will be able to dial up and get a file in any court in any part of the state and see what is transpiring in that case, and so that the public awareness of what's going on in the courts is going to be completed substantially. That's I think the ultimate benefit that will come from it. And of course, it's more efficient. As you know, if you make an airline reservation today, it's all done on computers. They do all of those sort of things. We can do the same thing in courts. We can be more efficient. We can handle more work with less people. But the ultimate beneficiary is going to be the public, because there will be more access to the files, and because you won't have to travel to the county where it is and pull out the file and look through it. You'll ultimately, when the system is finally completed, and if it goes the way we've designed it, you'll be able to access that from any public terminal in the state. And I think that's one of the real benefits to the public.
Thank you. Justice Johnson, we've been going back and forth between 1891 and 1991, and on the program today, to celebrate this 100 years, I know you chaired the committee that put the Centennial together, and there were citizens such as Scott Reed that were on that committee. And in a reception we had this morning, you did an eloquent job of describing the history of the court as far as the membership. We don't have a lot of time. I wish we had time to let you go through a lot of it, but would you give us some idea of the number who served on the court in this 100 years, and some highlights of what you think those members of the court have done for our state?
There have been 44 who have served on the court, including the 5 of us. And that means there have been 39 before us, and it is the lives of those 39 people that really has been the focus of our centennial celebration. The biographies that I know you were using to introduce the 5 of us are a result of some of that work. And having collected now that biographical material, I think as we go around the state, we're becoming more and more familiar with the lives of these people. We're finding that they were human beings, as we are. They have very great responsibilities, or had, as we do. And most importantly, we have learned through their lives, such as the life of Herman Taylor, that Justice Beislein spoke about, or Emory Knudsen, that they were outstanding human beings as well as being jurists. They had rich lives, and now reading their decisions is a much more rewarding experience, because at least I have a greater appreciation for what they did. Some of them served very extended terms, such as Alfred Budge, some 35 years almost on the court. And that kind of tenure and that kind of contribution is something that is very humbling when I think about the mere 3 years that I've spent in this process. But we collectively carry on that tradition.
I'm a person very involved in human rights, and I'm very interested in issues such as involvement of women and men in the process. And I know the court was very involved in the first woman who practiced law. Would you briefly tell us that?
On October 26th of 1895, the court, in the face of legislation that said only males who were 21 years of age or older and white could become attorneys in the state, the court decided that it was inherently within the power of the court to determine who would practice law in the state, and admitted Helen S. Young of Osborne as the first woman attorney. And today, of course, we have, as with Janelle Burke, a very talented group of women who share with us both in the judiciary and in the bar the responsibilities that we have.
Thank you. Janelle Burke.
I would like to continue following up on that historical perspective and ask Justice Boyle. Many of the earlier justices were previously trial court judges, but in the more recent past, a good number of justices, as the other justices here, have been practicing attorneys when they were appointed to the court. Can you reflect somewhat on that change as it's occurred in the court?
I believe that one of the reasons for that is that many of our trial court judges have thoroughly enjoyed their work and are content to be trial court judges. Having been on this court now for nearly 2 years, having served as a district court judge for 3 years, I have a good balance of time that I can consider and evaluate as to which job is the most interesting. I thoroughly enjoy this work. It's terribly challenging, but I miss at times the personal relationships that the district judges have with the attorneys, with court staffs, and obviously working with juries. I think that may be the difference, is that many of our district court judges enjoy that work so much that they stay where they are. I wanted to have the experience at both the district court and the Supreme Court. The reason I made that choice.
And Justice McDevitt, some of the justices on the Supreme Court have also served in other roles, other elected roles. For example, you were a legislator before you became a judge. Can you indicate what you think are the advantages of that system?
Well, I think the more breadth of experience that you have compositely on a court, the better off you are from the standpoint of understanding issues, understanding the human elements that you have to deal with. Oftentimes when the Chief Justice introduces me, he introduces me as someone who's had difficulty holding a job. I've practiced law, I've been a business executive, I was in the state legislature for 2 years, 2 terms. I'm now here on this court. All of us bring collectively an experience that is extremely important when you're dealing with intricate issues. Many of us have backgrounds that deal with some of those, help us understand how the issues were presented, how they were focused. So I think the greatest breadth of experience that you can bring to a group of this nature, the better off you are.
I wish we had time to continue to pursue this, Scott, but I noticed that we have very little time left, and I'd like to close out the program, if I may, on behalf of Janelle and Scott and our staff by saying it's been a very special privilege today to have all 5 members of the Idaho State Supreme Court. On behalf of our staff, and I know that the people of North Idaho, we congratulate you for the work that you have done with the Centennial work, and I think as Justice Johnson pointed out eloquently a moment ago, we all are learning more about the former members of the court, how they made decisions, and how the court of our state has been such an impact upon our lives. And I know in reading the materials that I did in preparing for this program, how much more enriched society we are as you and the other courts of our state have dealt with human relationships, and oftentimes when conflicts were resolved so that maybe those conflicts would not arise in the same way in the future. We're very proud to say that after this program is broadcast, that we will be providing it for the archives for the future study, and we thank all of you for being here in North Idaho with us to let us join in celebrating the Centennial. And I'd also like to say to our viewers, it was the pleasure of the Mayor of Coeur d'Alene today to declare today the Idaho Centennial State Court in the city of Coeur d'Alene, and that proclamation has been presented to the Chief Justice and the court. Thank you, gentlemen, for being here. Ladies and gentlemen, I know you found this to be a special program, and I would like to invite you to be with us again next week at the same time. Until then, please have a good week. I am Tony Stewart.
North Idaho College Public Forum is videotaped live by Telemedia Services on the campus of North Idaho College for viewing at this more appropriate time. We invite you to catch the North Idaho College Public Forum the same time next week on this television station.